this is a good moment for the ACLJ. We are seeing success happen again and again. And this one, you all may remember us talking about, which is a teacher who essentially was told, and you can give us, Christy, a brief sort of 101 overhead, was told, no, you can't be seen praying by anyone, by your students or anything. Again, not leading prayer. We're not talking about that. We're talking about she couldn't be in her car praying in the eye shot of someone on the staff and one of the students.
Exactly. So this all came up with See with the Poll, which is a standard thing that we've had in the United States for many, many years, where both teachers and then sometimes students will go before school, before classes, and meet at the flagpole for prayer. So our client is one of the teachers with a few other teachers. There were no students there, went in September and prayed at the pole. And then, of course, had the principal come and grab them from the pole, bring them into his office and tell them that they're never allowed to pray in the presence of students. And then when they responded with, well, it wasn't in the presence of students, there were no students there, he said, well, yes, there were students walking into the building that could have seen you. And you're not allowed to do that. That's school policy. So we brought our lawsuit and we just had a big win down in Texas. The court denied the school's motion to dismiss, which means our case is live, and the court effectively agreed with us that our complaint efficiently and sufficiently alleged all of the facts needed to go forward and win, that our client's constitutional rights were violated by this official school policy.
And Christy, for those watching, the motion to dismiss was brought by the defendant, so the school, the principal, wanting to have this case thrown out of court because obviously they're not wanting to be sued over it. So this is really like the big first legal hurdle that you have to get past. And sometimes if a judge doesn't want to deal with it, or if they don't think that it was enough standing is there to be brought, they can just get it out of their court, clear it out. But I want to read this from the opinion on this motion to dismiss because it bodes well for the future of our client in this as we go forward. But I also want to get your reaction when the judge writes, accepting the allegations in the complaint as true, Kennedy serves as an on-point case that clearly establishes that it is a violation of the First Amendment for a school to instruct its employee that she cannot pray in the presence of students. Therefore, Principal Rounds is not entitled to qualified immunity, meaning the principal was trying to argue that as an employee of the school district, he couldn't be named as one of the defendants in this lawsuit as well. But we claim big victory here because we have that next step. But now our team has a lot of work ahead. We need to now take this forward and fight in court to make sure that, yes, we survived one hurdle, but we have to get to the finish line.
Yes, it's very exciting for us. That one line from the judge was very strong in our favor, but that doesn't mean that we have an automatic win. And so the next steps here is we've got to go through what's called the summary judgment motion stage. So that's where we ask the judge to rule based on the evidence that's been presented and based on our complaint without having it to go to trial. And if we can win on that, that would mean we win the entire case. So we've gotten one step in, but now we have the big fight ahead of us with these summary judgment motions. So we're going to file one. I am sure the school is going to file one. We then have to respond to each other's. It's a significant amount of time, a significant amount of writing, and a whole team of attorneys that are going to be on this. So you're exactly right. We couldn't do this without your support because this is, we're talking 30 plus hours of our time, and you guys are making that possible so that we can do that for our client. And not just our client, but this is going to set precedent along with Kennedy for future school rulings. And so this is very exciting, but we need you to get it there.
And Christy, we know that while, viewers and listeners may think, okay, this is one teacher in Texas. We know that's never the case. We know that school, and you may be surprised that this is happening in Texas, but you know that it's happening all over the country.
It's one teacher speaking up.
Right. So if people have something similar happening to them, they can go to aclj.org/help, and our attorneys will be there to guide them through this process and secure victory for their constitutional rights.
Exactly. So if we hear of anything else like this, we can not only use the little win that we have here, but we can jump into court and try to bring another case as well. And so then the more cases that we have in all of the courts, the more likely it is that we can solidify this precedent moving forward. And right now, our whole goal is trying to determine where are the boundaries of the Supreme Court case in Kennedy. And that quote that you read from the judge is one step in helping solidify that these teachers do have the right to pray in front of students, maybe not in class time, maybe not when, the students are asking for them to do certain things, but when they're on their free time in the lunchroom, on snack, on break before school, of course they're allowed to pray. And that is what we're here to fight.
Thank you so much for joining us today. And look, these are very important issues. And I think people, like Will said, you can maybe look at it from a small scale and be like, this is sort of lowercase p persecution. Like you could say, hey, we know what's happening in places like Congo and where people are being murdered for their faith. And yes, this is not that. But the ACLJ is involved in that as well. So we're able to multitask. We're able to get an incredible team that can go all around the world, but also can go to Texas and represent a singular teacher to hopefully set precedent for the future, to say, of course, you can pray. Of course, you can pray in your car. Of course, you can pray before your meal. Of course, that is violating your not only First Amendment, but your religious freedom. You can pray before a meal. This is absurd, but thankfully, we have an incredible team that can get into action very quick. And you may even say, why is the state of Texas even pushing this? Like, why do they not just figure it out and settle it? Hopefully they do down the road. But what we like about this and what you can see this is that the ACLJ can get it done even when things may be hostile. We are so excited to announce the ACLJ's brand new app, completely redesigned to provide you with the best tools available to partner with us at the ACLJ. You can watch the daily Secular program, sign the petitions, customize your ACLJ membership experience, donate with the click of a button, and receive up-to-the-minute critical updates that the mainstream media can't censor. Just scan the QR code on your screen or go to your phone's app store, search ACLJ, and click install. It's that simple.